Hello, my name is Janan Jara and I'm one of the lawyers at eLaw Alliance. We're located in Edmonton, Alberta, Canada. Today I want to play a little game of child support, true or false. How it works is I will make a statement I often hear from clients related to child support, and then I'll tell you if that statement is true or false. Just to be clear, I'm not giving legal advice in this video, so if you're looking for specific legal advice, you're going to have to call me directly for that. So let's start our child support true or false game. Statement number 1. If I don't see my kids, or if my ex won't let me see our kids, I don't have to pay child support. False. Even if you don't have any parenting time with your kids, you're going to have to pay child support to the other parent. Child support is the right of the child, and there are very few occasions where you would be exempt from paying child support. Rule of thumb, if you helped create the children, then you have to help support them too, regardless if you see them or not. Statement number 2. My ex makes more money than I do, and he has day-to-day care of our kids, so I don't have to pay him any child support. False. If you are not the day-to-day parent, or if you don't have shared parenting, even if your ex earns more money than you do, you're still required to pay him child support. The child support will be calculated using your income. Look for online child support calculators to give you an idea of how much child support you'd be required to pay. Statement number 3. Even if my child is over the age of 18, I might still have to pay the other parent child support. True. The Alberta Family Law Act and the Divorce Act specify when child support is to be paid for a child who is over the age of 18. For example, if your child attends post-secondary education or schooling, or is still reliant on the parents, you might have to pay child support past the age of 18, and in some cases, until a child turns the age of 23. Statement number 4. If I refuse to provide my ex with my income information for the purposes of calculating child support, there will be no way to ascertain what amount of child support I should pay. False. Exchanging financial disclosure with your ex is mandatory so that proper child support calculations can be made. If you do not provide this information, a judge has the authority to do what we call impute income. That means that the judge can decide whatever he thinks your income should be set at based on what your ex tells him. In addition to that, if you refuse to provide your financial information, a judge has the authority to order costs against you. That would be if the matter went to court. So rule of thumb, in a child support matter, exchange your financial disclosure and avoid having your income imputed and having costs ordered against you. Statement number 5. I have to pay my ex child support even if she collects social assistance. True. If your ex collects social assistance or welfare, your child support payments must still be made, but in this case they would be paid to the government instead of being paid to your ex directly. Statement number 6. If I can afford it, I have to help my ex pay for my kids' extracurricular activities such as swimming fees and hockey fees. True. Fees associated with extracurricular activities are known as Section 7 expenses, and as long as the fees are within your ability to pay, you will have to contribute to those fees. Section 7 expenses are proportionally shared between you and your ex according to your incomes. Statement number 7. I can get away with not having to pay court-ordered child support if I just skip town and go to the USA. False. The USA and Canada are reciprocating jurisdictions, which means that a child support order granted in Canada can be enforced in the USA. There are many other reciprocating jurisdictions other than the USA. Statement number 8. If I refuse to pay court-ordered child support to the Maintenance Enforcement Program, they have the power to suspend my driver's license, confiscate my passport, and even garnish my wages. True. The Maintenance Enforcement Program, or MEP for short, is an agency in Alberta that handles the enforcement of child support orders, and it does have the authority to do all of those things I just listed. Suffice to say, they can make your life a living hell. If you can't afford to pay child support, talk to a lawyer about having it reduced legally the right way. Statement number 9. If I refuse to pay child support to my ex after she's requested it from me, she can go after me in court for those months that I didn't pay. True. If your ex asked you for child support and you didn't pay it, and she had to go to court to get an order, not only can the judge order that you pay ongoing child support, you can be made to pay for all those months you didn't pay. That's known as retroactive child support. Statement number 10. I'm an employee and my income fluctuates every year, so I have to go to court every year to readjust my child support amounts. False. If you're an employee and your income fluctuates every year, consider registering your child support order with the recalculation program. This program has the authority to automatically adjust your child support annually without you having to go back to court. There are a lot of details surrounding the issues of child support in Alberta. Give one of our lawyers a call and we'd be more than happy to give you a free consultation and provide you specific legal advice. That's it for today's True or False Child Support. Signing off from eLaw Alliance, where we stick up for people.